Good morning, everyone. Thank you for joining us from Chicago, from Indianapolis, from across the web. We're so glad that you're here. Jeff, I can see you. Can you give me a thumbs up if you can hear me? Okay, great. All right. Why don't we get settled and we'll kick it off here in just a moment. My name is Lisa Coop. I'm NIJC's National Director of Legal Services. I work very closely with our asylum team, and I'm very grateful to be with all of you here today. If you are new to asylum and contemplating taking your first pro bono asylum case, welcome. We need you so much, and we are so glad that you are here. So when we scheduled this training for this date, we did that knowing this could be a fraught time in our legal world. And here we are facing challenges that we certainly wished we would be able to avoid. We are worried about further erosion of the right to seek asylum. We are worried about attempts to narrow the refugee definition, and we worry about fear and hostility towards asylum seekers and refugees. But we refuse to live in a place of worry and fear, and thankfully, we are attorneys who have tools for action that we can use on behalf of the vulnerable among us. At NIJC, our values remain the same, regardless of the administration. We believe in human rights, we believe in family integrity, we believe in rule of law, and we believe that in the end, justice prevails. So thank you for joining us. We will spend the next 2 hours doing an asylum deep dive. Our aim is to give you the skills and resources to advocate for asylum seekers and position their cases to win, and if necessary, to shape the law on appeal. Together, we will win protection for individuals and families, and we will protect asylum law so that our communities can continue to be places of refuge for those in need. So let's do this. I'm going to kick it to Lily, who's going to give you a little bit of an introduction to NIJC and an overview of our work. Thanks, Lily.
Thank you, Lisa. And thank you all for coming today. We have had a lot of new registrations since last week, so we're so grateful. We're so grateful to you all for joining us, and we will go ahead and get started. So as I think you all noticed, the QR code in the screen here is for attendance. So if you have not already scanned it and signed in, please do so now. Looks like some people in our room are doing that, so I'll give you all a second. Okay, and we're gonna move on to our agenda. So we've got quite a packed agenda today, so we'll go ahead and jump in. We're gonna start with an introduction to NIJC, and then we will turn it over to one of our pro bono partners at Faegre to discuss the pro bono experience. And then we'll jump into asylum law. We'll do a brief overview before we get into the nitty-gritty and break down the elements of asylum. After that, we're gonna give you all a 10-minute break. And then we'll discuss more the logistics of an asylum case. So we'll talk about getting started with your client, working with your client, and the specifics of preparing and presenting an asylum case. And we'll finish out with a Q&A. We also have 2 colleagues online who will be able to answer any questions in the chat. My colleague Olivia Judd and Julie Rich. Okay, and these are today's presenters. I will let my colleagues introduce themselves. My name is Lily Henkel. I am the pro bono coordinator for the asylum team, and I use she, her pronouns.
You all already met me. I'm Lisa Coop, National Director of Legal Services.
Hi, I'm Ruthie, and I'm a staff attorney with NIJC in Indianapolis. And I'm so excited to be here with all of you and to collaborate with you guys as pro bono attorneys for our asylum seekers here in our community.
And I'm Jeff. I am an attorney on the asylum pro bono team.
I'm Cecile Harris. I am a staff attorney on the asylum pro bono team here in Chicago. And I want to thank everybody for attending today.
All right. Jeff, I think you need to give me control of the presentation one more time. Okay. Thank you all for bearing with our technical difficulties. This is the first time we're doing our asylum project training in 2 different cities. So there are a few kinks to work out. I'm not sure.
Jeff, it shows that the controlling is still in Indianapolis.
Oh, okay. Apologies. So on our end, it says that you are controlling the screen. Let me see if there's anything I can do. Okay, I just sent control to you again.
Yeah, we have control, but when I click on it, it's not changing the slide. So is it okay if you change the slide for me for right now, and hopefully we'll figure it out?
Yes, I can do that.
Thank you. Okay.
Did the slide change for you?
No.
Okay, then if,
Okay, we're seeing the correct slide now.
okay. I'm going to try one more time to send you control, see if it works now.
Okay. All right, we're back on track. So on the current slide, this is a list of our asylum pro bono contacts. All of the attorneys listed are available for legal, procedural, and strategy questions if you take a case with NIJC. So if you already have a case with us, it's likely that you're already in contact with someone on this list. If you take a case with us, you will be put in contact with someone on this list. On the other side of the screen are our coordinators. So if you have any questions about asylum project cases, you can reach out to me at the email provided. And if you have any questions about LGBTQ specific asylum project cases, you can reach out to my colleague Moises Lopez Soltero. If you check out our case list, our contacts are also listed at the appropriate cases. Okay, so this is just a brief overview of NIJC and what we do. NIJC's mission is to ensure access to justice for immigrants, refugees, and asylum seekers, and we've been operating for about 40 years. We have an integral service model that includes the 3 pillars that you see on the screen. So first is our direct legal services, direct representation pillar, which provides legal services for 11,000 plus non-citizens. And then we have our federal litigation branch, which challenges laws, policies, and practices that violate human rights. And then lastly, our advocacy team, which advocates for reform with members of Congress. And none of this is possible without our network of about 2,400 at this point pro bono volunteers. So all of you, we couldn't do any of this work without you, particularly our direct legal services, which is where our asylum project is housed. This is just a brief overview of how NIJC's pro bono programs work. Everything at NIJC starts with our clients. So an immigrant will come to us because they have a case and they are in need of representation. And then NIJC staff will conduct an in-depth case screening and assessment to determine whether or not we believe they're viable for relief. If we determine that they have a viable case, we can accept it, we sign a retainer with them, and then we represent them in-house while we look for pro bono placement. And then the journey ends with you all. We place a case with maybe some of you who are here today, and NIJC remains of counsel on that case. So that means we are here to provide attorney support, document review, and technical assistance throughout the life of the case. And because we are still of counsel, we have a vested interest in the outcome of this case. Our goal is to partner with you on this and obtain the best outcome possible for our mutual clients. In addition to our asylum project, we have a number of other pro bono opportunities. I won't get too in detail since we have a limited amount of time today, but we have a wealth of different programs. So if you're interested in working with children, you can get involved in special immigrant juvenile status predicate orders. We have a number of clinics that law firms can host, including, I will note, our pro se asylum clinics, which we started doing in the last year or so as a response to the growing number of recent arrivals in Chicago. Within our asylum project, you can work with a number of different kinds of clients. We have VAWA and U visa relief cases for victims of violent crimes. And then, of course, our LGBTQ Immigrant Rights Initiative, which is a population-based project and provides various kinds of relief for LGBTQ immigrants. And this is just to say, hopefully all of you are here because you already know that pro bono attorneys are important for immigrants, especially those in proceedings. As this graph shows, there are about 70% of cases in immigration court in the United States are unrepresented. In Illinois, that number is even higher. It's about 75%. And this is because non-citizens do not have the right to appointed counsel in the United States. That being said, NIJC maintains and has maintained for some time now a 90% approval rate in all of our cases. So if you take a case with us, we're going to provide you the support to win. And you really do make a difference in the lives of people in proceedings. And then in addition to just your client, there's a broader impact to taking on a case through NIJC. At an organizational level, we operate on a one-for-one model, which means that every time a pro bono attorney accepts a case, that frees up space for us in-house to accept a new case for representation. We also hear time and time again from our pro bono attorneys how impactful this work is for them. If you are an early career attorney in particular, representing an NIJC asylum client allows you to develop trial skills, to develop a relationship with your client, and to have the experience of managing an entire case. And then lastly, say you take a case, you win it, your client is now on the road to permanent status. They can also petition for their family members to derive status through them. And if they are outside of the United States, maybe even come to join them. So you're reuniting families, you're creating an opportunity for multiple people to get status. And then lastly, I just wanted to go over the wealth of resources that we have for attorneys on our website. We have in-depth manuals, we have live and recorded webinar trainings like this one. We have a very substantial sample document bank, country conditions databases, FAQs, and then lastly, as I mentioned, if you take a case, you have access to our immigration experts for any questions or concerns. They will work with you to work out any kinks. And with that, I will turn it over to Jacqueline to discuss the pro bono experience.
Perfect. Lily, can you hear me now?
We can hear you.
Great. Thanks so much. Hi, everybody. My name is Jacqueline Pimentel-Gannon. I am a partner in the nonprofit organization practice within the corporate group here in Indianapolis. And I am thrilled to be able to talk to you and share a little bit about my experiences with NIJC. I'm actually setting a timer for my time limit because I feel like I could talk all day about how wonderful NIJC is and just the incredibly good impact that they have in our communities. My introduction to both asylum and NIJC happened in law school when I was able to do an externship through NIJC and take on an asylum case that was, you'll learn more about this in greater detail in just a bit, but was in a phase where it was not in court yet. And so we got to prepare what's called an affirmative application for an individual from Eritrea who was persecuted because of his political beliefs. And we had the chance to, after preparing that, go with him to the asylum interview that is basically kind of like a hearing, but not in court, literally in an office, and then find out that he did receive asylum. And so he was able to stay in the country and not have to worry about going back and facing what could be ultimately up to death for his political beliefs. When I started at the firm, I was thrilled to find out that we partnered with NIJC on a regular basis. And so I volunteered to start on an immigration case really shortly after joining here at the firm. And in an example of how frustrating the asylum system can be in immigration law in general in the US, I am still working with that family. Now, some really weird extenuating circumstances, but know that if you sign up for a case, you will not necessarily be working on it now 13 years later, but there are ones that can happen much sooner and quicker than that. But essentially there was a family, two sisters from Guatemala, who a third sister was killed by a gang, and they were forced to, after being threatened with death, to take the two of them, and each of them had a child, to the United States. I think at this point it's a good time to mention that if you're not familiar already from having just heard about it in the news, like many of the people that we work with, I would say most, if not all of the people that we work with, never wanted to come here as a first option. These folks have experienced persecution and threats on their life, violence, domestic violence, sexual violence, all sorts of horrific beatings and deaths of family members. And it was really, I think, a last result for many of the people that we get the chance to work with to come here literally to save their lives because they were afraid for their lives. So the chance to do something to help these types of people, as was mentioned on the slides, there are so many that are unrepresented. So I took that to learn. At first, I was very worried, like, I don't know what I'm doing here. I am not an expert. I am not an immigration lawyer. I don't want to mess things up for the people that I'm working with. And what I have learned and what I have found is that if I'm willing to just put myself out there and try, there is a setup in the way that we work with NIJC where we have such support that the difference between being unrepresented and having someone who might not know immigration law, like the back of their hand, but is willing to use the resources that exist both through our firm and the people that are on our teams. We won't do these alone. You're going to be working with other people at the firm as well. And then to be backstopped by NIJC, who are the experts, to know that there are so many resources that exist that when you get stuck and there's a sticky situation and you don't know what to do, help is either on the website and the resources there or a phone call or an email away. It's really reassuring and has been to me. So I'd encourage you not to worry that you're not an expert, even if you've never done one of these cases before. I think that the opportunity to help these folks who come in, when they come in, they often are faced with a situation where they have to answer questions in a language that isn't even their own. So with no help guaranteed, even in terms of language, let alone legal assistance. And so the benefit that we can provide by being able to step in and offer this assistance is, I think, life-changing for these individuals and has been life-changing for me as well. The most meaningful experiences in my legal career have been working with immigration and particularly asylum clients whose gratitude, even for just listening and hearing them and being a comfort. We can't change the horrible conditions that many of them have already suffered, but we, even just a smile and patience in hearing them out and expressing concern when they share the really painful memories and events that they've experienced, I think goes a long way and is always so greatly appreciated. It was mentioned that a lot of skills can be developed. I'm not a litigator, and so while I might not put into my daily practice the skills of being in court, which you would do in what's called the defensive immigration case, I have still learned a lot and been able to have a lot of hands-on experience, even very early on, with working directly with clients, and it has been something that has been beneficial to my career, but I would say far more than that, it's been beneficial in just being an incredibly fulfilling and rewarding experience to get to help on these matters. NIJC is a great source of support, and they are literally there to help answer questions and work through tough situations and details with you. And you're in incredibly good hands. So I would encourage you to consider joining an immigration team after you have finished this training. I can practically guarantee you that you won't regret it. And if you have any questions or want to talk through any asylum related things, please know I'm always here. Feel free to reach out. Thanks so much.
Thanks, Jacqueline. Jacqueline and I were very new attorneys together and have been partnering on asylum cases for a lot of years now. So as Jacqueline said, not every case spans more than a decade, but it's also valuable to be in the fight for the long haul if that's what we need to do. So I'm going to shift us and do an overview of asylum law, and then we'll dig deeper on the elements of asylum. So it says that I can control the screen. I can't. Lily, if you can forward slides, if anyone's got power to just forward slides, we can just do it that way. So basics of asylum law. Let's start with who are the players involved in these cases. A lot of you practice law in more traditional, and so some of this is going to feel a little different and new to you. In some ways, immigration court feels like the Wild West because the rules are different, the players are different, the structures are different. But doing the things that you already do, bringing your skills from other legal contexts really serves your client. So the Executive Office for Immigration Review is a part of the Department of Justice. So this is where asylum law is vulnerable to be really politicized, right? Because the Attorney General sits at the top of the Department of Justice, and the Attorney General really gets to shape a lot of our immigration policy, including setting precedent decisions. So when I say, hey, our laws could change in the coming months, it's because of the way the Board of Immigration Appeals, the Executive Office for Immigration Review, and the immigration courts are structured. So expect to see in the coming months some pronouncements from whoever our new Attorney General is, sort of reinterpreting immigration law. But so Department of Justice houses our courts. So our immigration courts are, until now, when we gave these trainings, we talked about the Chicago Immigration Court. There will be an Indianapolis Immigration Court that will be opening imminently. We expected it to open its brick and mortar space in the Federal Building there in downtown Indianapolis this month. It looks like they're going to push it until January, but we do expect to see a court open in Indianapolis, and that is very significant. One, because that means 60,000 people who are in removal proceedings in Indiana will no longer have to travel to Chicago for court, but will be able to attend court in Indianapolis. It also means that we're really hopeful that the pro bono community in Indianapolis will feel ready to step in on some of these cases. And instead of having to drive up 65 and get to Chicago and go to court, it's something that will hopefully feel more accessible. And so we're really hoping that this leads to an increase in capacity among the pro bono bars and in representation of asylum seekers and other immigrants who are appearing before the immigration court. So that piece is in the Department of Justice. The Department of Homeland Security, which was created in 2002 through the Homeland Security Act, houses the other immigration components. So when we talk about United States Citizenship and Immigration Services, that's the benefits branch. When your clients become eligible to apply for work authorization, that's the agency that we're applying to. Jacqueline talked about these affirmative asylum interviews, where sometimes your client has a non-adversarial interview with an asylum officer. That happens at USCIS. And then their partner agency or sibling agency in the Department of Homeland Security is ICE, which is Immigration and Customs Enforcement. So when we're talking about who is our opposing counsel, when we go into immigration court, so the judge works for DOJ, our opposing counsel works for the Department of Homeland Security and is a part of ICE. And then ERO, so if you have a client that is on an alternative to detention, so that could be one of those monitoring watches or ankle monitors that people have to use to report their movement and their behavior, that might be in connection, or that might have started with, that might be a part of enforcement and removal, which is a part of ICE. And then there is CBP, which is Customs and Border Protection. That's the Border Patrol. So the other component that you might see is the Office of Refugee Resettlement. If you have a child client who entered the United States as an unaccompanied minor, they may have gone through the custody of the Office of Refugee Resettlement. So you might see some of that documentation relevant in your cases. And then, of course, at the center of this all is the asylum seekers and their families. Our role, your role, is to help them navigate all of these spaces and understand these different entities and decipher the system for them. So let's move forward to the next slide, where we will talk about Let's see. Who's got the clicker? There we go. Our legal sources for asylum law. So in a second, we're going to look at the definition of a refugee, which I'm using those terms asylee and refugee a little bit interchangeably, not because they're legally the same thing, but because they fall under the same legal definition. So in the 1951 Convention on the Treatment of Refugees, which was created by kind of then the League of Nations in the early days of the United Nations, there was this definition that everybody came up with that recognizes who gets to be a refugee, who are the people that are allowed to access protection when they have to flee their home countries. And that definition was codified into our U.S. immigration law in 1980 in the Refugee Act. And so we have our Immigration and Nationality Act, or the INA, at Section 208. That's where you're going to find the statutory guidance on what is asylum, who qualifies for asylum, and then that's put into effect through the regulations at 8 CFR. So it's either 8 CFR Section 208 or 8 CFR Section 1208, depending on whether your client is appearing affirmatively before the asylum office or is in immigration court. I will say the vast majority of the cases that are on our case list for which we're seeking representation are cases that are before the immigration court. So we're really going to focus our presentation on cases that are going forward in the adversarial immigration court deportation process. And then kind of the third place you're looking for law for guidance is, of course, in the form of case law. I already talked about the Board of Immigration Appeals, which is, again, that administrative appellate court that's a part of the Department of Justice that's under the control of the Attorney General. So the Board of Immigration Appeals can set nationwide precedent on immigration law unless and until the circuit in which a particular immigration court sits does otherwise. So this is really important to us here in the Seventh Circuit, because the Seventh Circuit, for example, has asylum law that tends to be better than what the Board of Immigration Appeals has set forth. And that's because in the Seventh Circuit, the court has never deferred or offered Chevron deference to some of the interpretations of asylum set forth by the Board of Immigration Appeals and prior attorneys general. Now, we're in Loper Bright land. Chevron may or may not hold. I mean, like, there is no Chevron, right? So how the law evolves and changes in the coming years, I think, will be really important and really interesting. And that's just another reason why it's so critical that asylum seekers have counsel to help them prepare their cases and petition their cases to protect our good law and create good, strong records. So let's hop to the next slide, which is the asylum definition that I was just talking about. So a refugee is somebody outside of their country of origin who's unwilling or unable to access protection owing to a well-founded fear. So this is when you tune into those legal terms of art, a well-founded fear of persecution on account of race, religion, nationality, political opinion, or membership in a particular social group. So your attorney brain should all be tuning in that these are all legal terms of art that will define who gets to be recognized as a refugee and who gets to win asylum. Because if you are in the United States and you want to be recognized as a refugee, asylum is your process for doing that. If you're outside of the United States and you're going through a refugee camp or you have contact with the United Nations High Commissioner for Refugees, then you might establish you meet that definition and then be resettled in the United States. So you come in already having status. Asylum seekers, our clients, the people we represent, are people who did not have that recognition happen before they arrived in the United States. So they're trying to show that they meet. So this is the ultimate goal, right, in our asylum cases, to establish that our clients meet this definition within the United States and should be recognized as refugees and granted asylum. So let's go to the next slide. And that, of course, breaks down into elements. And we're going to talk more about these elements. But the biggest piece of legal guidance, I think, that we offer is that you have to keep these elements separately, that asylum law becomes kind of a jumble of confusion when we allow our opposing counsel or judges to kind of like blend all of these elements into one thing. And we win asylum by going through step by step, by creating a roadmap for the immigration judge or the adjudicator to understand that our client has a well-founded fear. So that's our legal standard. And we're going to talk more about this, establishing a 10% likelihood of harm in the future. And 10% is low, right? Like, it's not more likely than not. It's not beyond a reasonable doubt. It's a 10% likelihood. And so it's really important to keep that in mind and remind our adjudicators of that. That well-founded fear has to be of harm that rises to the level of persecution. So we're going to talk about drafting affidavits and all sorts of things. Whenever people use terms like harassment, that's not persecution. Let's keep that out of our case preparation. Let's focus on establishing the harm that rises to the level of persecution. That persecution has to be either by the government or someone the government cannot or will not control. So if you can get protection in your home country, if your police can protect you, that's not asylum. Then you're not a refugee and you need to tap into those protections. The reality is for our clients, that's typically not the case. And then that on account of, this looks like an innocuous little line here, on account of, but this is maybe one of the biggest, most nuanced parts of asylum is this nexus. You'll hear it described as the nexus element, the connection between that persecution and one of those protected grounds, race, religion, nationality, political opinion, or particular social group, which will probably shorthand as PSG. If you hear us say PSG, we're talking about that particular social group ground of asylum, which my colleagues will go into more detail about in a moment. But really your takeaway here is these elements need to be working in concert. And as we're preparing our cases, we're thinking through all of these 5 pieces and how do they work together and how do we show that our clients satisfy all of them. So let's hop to the next slide, which is on the 1-year filing deadline. Asylum seekers have to apply for asylum within 1 year of arriving in the United States. If they don't, they have to show that they meet an exception, whether that's changed circumstances or exceptional circumstances. So for example, we had a client recently who was pregnant and in the hospital and had preeclampsia and missed her filing deadline because of acute medical issues. That might be a reason for missing your 1-year filing deadline. Or we have clients in our LGBTQ project who maybe aren't able to come out or transition or recognize their identity until they've been in the United States for more than a year. That might be a reason why somebody has waited more than a year to apply for asylum. So I'm really reluctant to say there's some kind of blanket rule that once you're past that 1 year, you're done, you're out of luck, you can never seek asylum. But if it is at all possible to get those applications filed within the 1-year timeline, we absolutely want to do that. So if we're coming into contact with a client before their 1-year filing deadline, we're trying to make sure that application gets in. If we accept a case for someone who is outside of that 1-year filing deadline, we will note that in our case description before we place it with a pro bono partner, and we'll help you build arguments to get around that deadline to make sure that your client can access protection. Let's go to the next slide, which has circled at the top. So this is the I-589. This is the thing. This is the asylum application. For people who don't qualify for asylum, maybe because they missed the 1-year filing deadline or for some other reasons, there are still other forms of relief that we want to make sure we are preserving. And one of those is relief under the Convention Against Torture. And so there's a little box at the top of the I-589 that's really easy to miss when you're filling out that application, but you want to make sure that that box is checked because that tells the court or that tells the adjudicator that you are also seeking relief under the Convention Against Torture. The third form of relief is withholding of removal, which is in a lot of ways very similar to asylum, but has a higher burden of proof and less great benefits. But withholding of removal is not discretionary, and it's not subject to the 1-year filing deadline. So for people who are knocked out of asylum eligibility for one of those reasons, they might be eligible for withholding of removal. And when we file that I-589, we're doing all 3 at once. So there are not three separate applications that you file. You file that I-589, you check that box, and you don't have to do anything else to apply for withholding of removal because the application itself is for asylum and withholding of removal. So that next slide goes into the requirements for withholding of removal, which again has that higher burden of proof. So remember, we just talked about asylum's kind of nice because you got that 10% likelihood of harm. In the withholding context, you have to show that there's more than a 50% likelihood that your client is going to experience persecution. And then all of those other elements basically remain the same. And there's some more nuances. For example, clients that have had contact with the criminal legal system can sometimes be knocked out of asylum eligibility, but they might still be eligible for withholding of removal. So that's a really important thing to make sure that we're preserving. I would say most often, unless you think your client might be knocked out of asylum eligibility, we're not spending a ton of time building out withholding and torture convention arguments. We'll preserve those in our brief, but unless we think there's a real risk that asylum might not be granted and we might have to lean on withholding or CAT, will really stress that asylum claim. One of the big differences and one of the reasons we want to fight for asylum is something Lily mentioned at the outset, which is that when people win asylum, they can petition to bring their children, their spouses to the United States if they had to leave them behind in the country of origin. And so you can't do that with withholding of removal. Withholding is just the withholding of your deportation. It's not additional benefits. And so wherever possible, we're fighting tooth and nail to establish our clients are eligible for asylum. CAT relief, I'm seeing the question in the chat. CAT is also not subject to the 1-year filing deadline. So CAT is sort of oftentimes like our last resort relief because you can be eligible for relief under the Convention Against Torture if you've missed the 1-year filing deadline, if you've had really complicated contact with the criminal legal system, if you have some criminal convictions that might make you ineligible for all other forms of relief, you may still be eligible for relief under the Convention Against Torture. The thing about CAT doesn't have all of those other elements. You don't have to show a nexus to one of those protected grounds. CAT is available to people who face torture in their country of origin. So again, you've got to show that it's more likely than not that you'll face torture. Torture is different than persecution. So you're facing harm, and here, whereas in asylum and withholding, you're trying to show that the harm will be by the government or someone the government is unwilling or unable to control. In the CAT context, you have to show that the torture will be inflicted by the government or with government acquiescence. And government acquiescence is different from government unwilling or unable to control. So again, most of the cases that you'll see on our case list, the primary form of relief that we're seeking is not relief under the Convention Against Torture. We are always going to preserve it. We're always going to have a little paragraph at the end of our brief saying, hey, judge, if you can't do anything else, please grant us CAT. But by and large, your focus and your representation is going to be on building that asylum case. So we can go to the next slide. Which is what we've already been talking about, these different levels, different types of benefits that are available for different types of relief. So again, we are almost never going to concede that our clients are not eligible for asylum and are only eligible for withholding or relief under the Convention Against Torture. I'll say these distinctions have become much more poignant since May of 2023, when the current administration issued a raft of regulations that are known as the Circumventing Legal Pathways Rules. So for people that entered the United States after May of 2023, there are additional requirements to establish asylum eligibility. So those rules said, hey, if you entered the United States between ports of entry, if you didn't use that CBP-1 app to schedule an appointment to come in, if you're someone that just out of fear for your life fled through the river, across the desert, over the wall, you're not eligible for asylum. You're only eligible for withholding of removal, and you need to establish that you meet exceptions to those circumventing legal pathways rules. Again, those are only cases of people who arrived after May of 2023. There's much more to say about those regulations, which are currently under litigation by NIJC and our partners, because we think going back to that refugee definition in Section 208 of the Immigration Nationality Act that says anybody in the United States who needs asylum can apply for asylum, we think that these rules violate the statute in that way, but it is important to be aware of these other forms of relief, because if someone is found subject to those rules and not eligible for asylum, then we need to be ready to show the other protection that they're eligible to receive. So let's hop to the next slide. And I think now we're going to go into a deep dive. So that's your bird's eye view of asylum law, and now my colleagues will take us into the weeds a little bit on these different elements.
Thank you, Lisa. Let's see if I can move this forward. Okay, we're going to go into the elements of asylum now. And I think it's important to note that we're going to start thinking about these as we're interviewing the client, as we're preparing their affidavit, as we're preparing the documents that we need in order to prove their case. Let me see if I can move this. Next slide, please. Okay. Okay, let's go over the asylum elements again. It's easy to remember that there are 5 asylum elements and that there are 5 protected grounds. So well-founded fear, we'll go into that a little bit. So the person's afraid of persecution, and this is the type of harm that they suffered in their home country. And again, we'll go into it a little bit and define what persecution actually means. by the government, so the police, the military, security forces, or an entity that the government cannot or will not control. So this can be, say, gangs in Guatemala, or a family member in Venezuela who might be harming their spouse or their children. On account of is, again, as Lisa said, it seems a little bit innocuous, but it's really something that will bind everything together. This is the why, the how, the nexus that connects what happened, the harm that happened, to the 5 protected grounds. So the 5 protected grounds are things that people cannot change about themselves, so their race or their nationality, things that people should not have to change about themselves, like their religion or their political opinion. And then the last one is a little bit more broad, but this is something that that NIJC has been working quite a bit with, and we will also work with the pro bono groups about establishing whether the asylum seeker will fall into membership in a particular social group. And that also, membership in a particular social group also will be immutable characteristics, where people cannot change those characteristics or ought not change those characteristics. So they could be persecuted on things such as gender, their sexual orientation or identity, or who their family might be. And remember to always keep them separate in your mind. You don't want to conflate them because it just confuses the judge, and it's also confusing for you. This one? Okay. Okay, so the first element is a well-founded fear. And so to establish this, we establish it in 2 ways. First, we will look at all the asylum elements for an individual. So let's say a woman from Congo was thrown into jail and was attacked and thrown into jail by members of the government, maybe security forces, because they thought that she was against the government, that there were things that she was doing that was against the government. And so all those elements could be established, and these all would have happened in the past. So as long as all the elements are established in the past, that would be considered a well-founded fear, and that these elements could also occur in the future. So again, when you have the past elements and add the future elements, there's a burden of proof with regard to the future elements, and that is that there's a 10% chance, a reasonable possibility, that it could happen again. So the woman in the Congo, from the Congo, who came to the United States and fled persecution there, if she were to return to Congo, there is a 10% chance that she could be found again if she went back to her home and be persecuted again. We try to argue both whenever possible. So we're going to go forward and talk about those. Okay, so generally, many people who come to the United States or flee to the United States have experienced some sort of harm, some sort of persecution in their home country that meets all of the asylum elements. But this is also, there's also a rebuttable presumption that the same persecution, the same type of harm is also going to occur in the future. And this presumption, the presumption is rebuttable by the government. So the government can show that, well, circumstances in the country have changed. There's a new political regime and they are now democratic. And so the type of harm that our asylum seeker in the Congo had experienced before is not going to be present if she returns to the Congo. and or that there is a safe and reasonable internal relocation for our asylum seeker from Congo. So the government has to show that she can go back to Congo and she can live in a different part where her persecutors may not find her or may no longer be present in order to find her. So sometimes all the asylum elements that our asylum seeker might be presenting may not arise to persecution. And so we would look at the possibility of well-founded fear in the future. And so we'll look at their subjective, genuine fear. So their story is really important here, where they tell you, this is what happened to me. It might not arise to persecution, but it's enough that you can add it to their subjective, genuine fear. And then the second element would be to objectively reasonable fear. So those are objective, there's objective. So we're looking at evidence like country conditions, reports, maybe from the State Department or from Amnesty International, that these are the types of persecutions that occur in the Congo. We'll also want to try and make sure that all the elements are met there, where people in a similar situation would also be persecuted by a similar group if they stayed in the Congo. And again, the test is reasonable possibility that this is going to happen. You can also show this by providing an affidavit from an expert witness regarding the conditions in the Congo, maybe witness statements from others who maybe had experienced similar types of persecution, similar types of harm in their country. And then again, to argue that there's no safe or reasonable internal relocation, and the same types of evidence would be used to show that nowhere in the Congo is safe for this woman who appears to be against the government. And so all that added together is a well-founded fear of future persecution. Okay, so let's take a look at what persecution actually means. There are three types, and the definitions of persecution are actually discussed in the specific case law, Stanikova v. Holder. So in Stanikova, there is a man and a woman, husband and wife, and the wife is pregnant. And there are also her parents who are all in their apartment. And at some point, members of the government broke into their apartment and immediately sprayed a toxin onto the parents. And so both the parents passed out. And then in order to show that they were really serious, they, in front of the husband, began to grope his wife, his pregnant wife, and ripped her clothes. And then, now I can't remember, but I think they also beat up the husband. So let's just say that they did. And so the three types of persecution could be, I guess, gleaned from these, the fact pattern in Stanikova. So first is a significant physical force against a person's body. And so the assault on the husband, the assault on the wife. In other cases, it could be somebody who is beaten with a baton or kicked in the face, or hit by a car. So these are significant physical forces that are against a person's body. And the second type is the infliction of comparable physical harm without direct application of force. So the husband is witnessing something that's happening to his wife. He thinks that she's going to be assaulted even more. That is the type of harm that may not be physical or significantly physical, but it's something that is significant enough as if it were comparable physical harm. And then the third type is non-physical harm of equal gravity. This is more like psychological, but it can still also be used if, say, so the husband is watching something happening to his wife that is that would have a psychological harm on him, or watching his parents being drugged and falling over and not knowing what's happening with them. That would be an example of non-physical harm of equal gravity. Also, if we're looking at harm for children, generally younger than someone who's a minor, harm for children could be considered, you can consider lesser harm to be persecution for children just because of their age. For instance, a young child who might witness a car bombing in front of his house, maybe that's not going to be rising to the level of persecution for an adult, but that could rise to the level of persecution for a child. And then finally, we have to consider it cumulatively. So the sum of all their experiences added together would be considered persecution. Oh, okay. So now we have a hypothetical. And you can read along with me, and then afterward, we'll talk about what forms of harm you might see. Patricia is a woman from Haiti. Growing up, her father was a leader in a political party, and Patricia helped to support the party's campaigns when possible. Patricia's family received many threats due to their involvement, and one day, a group of armed men came into their home, beat up Patricia's father, put a gun to his head, and threatened to kill him and his family if he continued his political involvement. When he did not quit his political party, his family continued to receive threats. Later, a previously incarcerated gang member forced Patricia into a relationship with him. For several years, he regularly raped and tortured her. Eventually, Patricia escaped and moved to Chile, where she lived for a few years with the father of her children. However, Haitian migrants were regularly attacked in Chile. After Patricia's children's father began to abuse her, she fled to the United States with her daughter, Odette. So I don't know if anyone has an idea of what types of harm might be involved here. There's physical harm. Yes, there's physical harm. Where they beat up Patricia's father. And then Patricia's partner also attacked her. Oh, sorry, go ahead. Go ahead.
There was non-physical harm with threats to her family.
Yes, that's right. Non-physical harm with the threats to harm his family.
Rape and the torture.
Definitely.
Can you repeat? Because I don't know if they're on the mic.
Oh, yeah, sorry. So
I said the rape and the torture seem like the key things because that was harm to her. I'm not sure about the harm to her father. I'd be interested in the relevance of that and whether it's relevant or not. Because the harm to the father is not harm to her, but I don't know.
yes, so yes, the rape and the torture of Patricia was physical harm to her. If the father were present and watching, that could be, or were forced to endure that, then that could be considered non-physical harm to him of similar gravity.
Just to jump in as we're also getting some answers in the chat. I do want to add on to that question a little bit because I think it is a really important point. In some cases, harm to a family member can be harm to the asylum seeker, sort of kind of on an imputed or vicarious basis, in the sense that if you harm someone's children to hurt them, right? Your political opponent, you start arresting or killing all of their children, that could be a way of harming the political opponent. And so in that kind of situation where we have the harmable or family members, that's the kind of dynamic you would be looking for. But really why I broke in is we were getting some good mentions in the chat that looks like there's some persecution based on political opinions or nationality, which are protected grounds that we will get to shortly. And also, someone mentioned how they were attacked in Chile, which is not going to be directly part of the asylum claim, vis-a-vis Haiti in itself. But one of the issues that we aren't going into for time is whether someone became permanently resettled in a third country. And in that case, those types of attacks become potentially very salient. And just in the interest of time, I think I'm going to move us on to the next question. I know people have more ideas. Happily, we are going to stick with Patricia and her story and return to this 3 more times today, 2 more in the very near future. So there will be more opportunities to get comments and questions in. So I've talked about the asylum elements as being a well-founded fear of persecution. By whom is the next important question. And as Lisa mentioned, the fundamental thing that we're talking about here is protection. Can the person's government provide protection such that they need to seek protection in the United States? And so the persecutor has to either be the government itself or an entity that the government is unable or unwilling to control. And when I that's unable or unwilling, not able, unable and unwilling. And so it does not have to be the state. That's a very important point that people don't necessarily know intuitively without looking at some of the case law. And when we're talking about government entity, we're talking about it at multiple levels, right? Like from the president down to the military, the police, whoever. Or the government could involve quasi-governmental entities like a paramilitary force, right? Not acknowledged by the government, but doing things on the government's behalf. Or in many cases, there can be a strong argument that gangs have a quasi-governmental function, that they, in some, say, regions within the country may exert such a level of control that they are functionally who provide protection. Sometimes they're who provide access to fundamental services like transportation, even electrical grids and things like that. So when you get to those quasi-governmental entities, there's a little bit of a more complicated legal space of whether they're government per se, but it may be arguable that they are acting as a government. When we're talking about the entities that the government's unable or unwilling to control, the gangs and military groups will fit comfortably there, guerrilla groups opposing political parties, but it could be family members. And the really easy illustration of this is there are jurisdictions in the world where the police will not enforce domestic violence laws. Right? Like you could go to them and ask for protection, and they will say, as a family member, talk to your husband, or they will report to your husband that you came and talked to them. And if that's the case, there is no government willingness to help, or the gangs maybe are so powerful that the government cannot help, and maybe they've infiltrated the police to an extent that you might as well be telling them that you are informing on them because they will find out. those are situations where this element will be met. And so let's go back to Patricia and think about who caused the harm here. And and so who do you see as a persecutor in this scenario? I won't read the whole thing again, but hopefully you remember from a moment ago. Who's causing the harm, and how would you fit them into that framework?
Okay, we have the group of armed men.
Okay, great. Group of armed men. And and I think this is a case where we might need to know a little bit more, or try to ascertain what we can about sort of who they are in the relationship to the government. But from the context, it seems that likely they have some kind of relationship with political parties. I believe there was an answer here.
As a person that the government is unwilling or unable to control.
Absolutely, and I'll just repeat that into the mic, that the gang member who raped and tortured Patricia is potentially an entity that the government is unwilling and or unable to control. That's great. I keep thinking about this. We'll come back to this hypothetical again in a moment. Once we talk through our last two of the protected grounds. So again, well-founded fear of persecution by one of those two types of entities on account of a protected ground. And on account of and protected ground are separate elements. Cecile already highlighted this. It is crucial to keep in mind. And really what we're saying by that is that the causal nexus between the persecution and the protected ground is itself an element. It's itself the subject of case law. It is itself something with a particular burden of proof and set of things that you need to put into evidence. And so you have to think of that causal link separately from the harm and the protected ground that are on either side of that link. And when we're thinking about that causal nexus, the standard is that the protected ground is at least one central reason for the persecution. And that this is for asylum. Actually, the withholding statute, which you'll recall is similar, says a central reason. Whether that is a substantively different thing from one central reason is something that is subject of litigation that we won't go into, but it's something to think about if you are interested in, and if you are working on a case that withholding would seem like a salient issue. The persecutor can have mixed motives, right? So when we're saying one central reason, we're not saying the only reason. In reality, people harm people for lots of reasons all at once. And the question is, was that protected ground a significant factor, and how can you show that it was central to that persecution? Not that it's exclusive, but just that it plays a major role. And when you think about how to prove that, we will talk about various kinds of corroborating evidence in the second half of today's presentation. We will go pretty deep in that, but at a very general level, you can look at circumstantial evidence. I mean, sometimes you will have direct evidence. Sometimes the persecutor will say, this is why I'm harming you. The kind of easy example of that is while they were out of power, the Taliban would still send political enemies letters on official letterhead with a stamp saying, we will kill you for being an infidel and working with the Americans or whatever. And so like there you have very clear direct evidence, but a lot of times, most times, it's going to be more circumstantial. It's going to have to do with the context in which the evidence occurred, the kind of practices in the country conditions, evidence that you will look to understand what happened. And what we have listed here is MO, modus operandi, that sometimes groups particulate similarly situated, they target similarly situated people on an iterative basis. And if this keeps happening, you can see the pattern and infer from it what is happening. Now, we've been saying protected ground again and again and again, and you're probably wondering, what does that mean for asylum law? This is a huge topic. We've done several trainings on just one of these protected grounds. So we're going to just do the very bird's eye view. There are 5 protected grounds for asylum law. Race, which is articulated in the refugee treaties broadly to mean not just sort of what you would understand in most US legal contexts as race, but like various ethnicities can all fit into the race definition. Religion, which can be differences within a religion. The very obvious one is Sunni and Shia as both branches of Islam. But even within, say, Sunni Islam, you might have fundamentally different interpretations of the Quran, the obligations, and what religious practice looks like, what people are permitted to do. And in some cases, that can rise to a religion-based protected ground, or not having a religion. Atheism, apostasy can also fulfill this part of the analysis. Nationality is usually citizenship. It can also mean linguistic groups in some cases. Anglophones in Cameroon is an example that is in my head for some reason. Political opinion, it could be actual, like I am part of the party that opposes administration, or it can be imputed. I am a family member of a prominent political figure, and so I am presumed to oppose this administration, something like that. Or membership in a particular social group. The most complicated and in many ways most often legally challenged part of this. And so again, can't go into all of the details, but at the simplest level, it is a group of persons, all of whom share a common immutable characteristic. That is from the fundamental matter of Acosta. That is the standard setter. It's the only standard that the Seventh Circuit has deferred to. It is, as Lisa alluded to before, that there's going to be a lot of potential rulemaking, a lot of EIR decisions, a lot of litigation in the foreseeable future over asylum law. This definition is one of the areas where a lot is likely to happen. And shamelessly, I will plug us as NIJC, because as attorneys who specialize in this, we are always staying on top of these things, keeping up with those changes. And anytime that you take a case with us, we will make sure that you are up to date as well. Easiest way to do particular social groups in short form is to look at some examples. So some common framings that might see would be something like Salvadoran women or girls, the females of a particular nationality, immediate family members of a particular person. Family has long been regarded as one of the prototypical social groups. Women in intimate relationships, they are unable to leave. This is based on a key Board of Immigration Appeals case, ARCG. Women who have disobeyed gender norms. This was recognized by the Seventh Circuit in the Sarhan case that was alluded to before. A lot of sexual orientation, gender identity claims can fit into particular social groups. And again, I want to plug our LGBT project for doing amazing work in that field. And and I already mentioned kind of family-related claims. The one where we have a question mark is opposition to gang claims. And just to kind of explain briefly, opposition to a gang is not necessarily itself, just in saying that phrase, enough to say that you fit into a particular social group. But this might be sort of how a client explains to you what their situation is, why they were in danger. And so then you have to kind of dig a little bit deeper and see, like, are there other reasons why this gang was targeting them? Are there potential family-based claim, or was there something about what they were asking them to do that is part of the cultural norms of that region, similar to what we were saying with Sarhan disobeying gender norms, like, are there norms imposed that were being defied that the gang was responding to? Are there maybe a witness who testified against the gang? There are all kinds of potential routes that this can go. And so, you always dig deeper and think about really why the person is being targeted to understand a particular social group. And again, when we're placing cases, we do this legwork up front. And so we will have situations where we've seen these grounds, and some examples from our case list, just to go through quickly, are a woman from Ecuador who's endured years of domestic abuse, followed by escalating threats of violence against her and a new partner after she tried to break off the relationship. If it's some of the first PSGs that we talked about a moment ago. Or family from Angola who were targeted for kidnapping and other violence for refusing to support the party in power. You see the political opinion there. A gay man from Honduras who was violently attacked by a group causing anti-LGBT slurs and subsequently mocked and extorted by the police. This is a place where the wars of the persecutor show you the reasons for the persecution. And a man from Colombia who was targeted by an armed group due to his work as a community leader. And now to apply this, and unfortunately, this is going to have to be incredibly brief because of the timing, and I apologize for that, but would maybe a couple people like to just identify protected grounds that they see as potentially applying to Patricia's case?
We have an answer: family and gender, from the Chicago office.
Yes. Those are both great points and both arguments that I would make here. Does anyone see?
We had a second answer: political opinion.
Political opinion, yes, absolutely. Yeah, and I think there are more options that could potentially pull out of here, but in the interest of time, I would say that those three ways of framing it are ones that very strongly stood out to me, and I think they are all very strong framings. Again, we see the familiar relationship to the father who was politically active, the nature of the violence that she endured suggests a gender being a key element, and if at the very least it seems like there's an imputed political opinion here. As someone said in the chat, imputed political opinion, and I think imputed is just based on what we have here, how I would frame it. And
sorry, one more answer from Chicago: nationality.
Yes, and nationality, great, excellent. And so, okay, I think that is all we can take for this question right now, but keep thinking about it. If and I know there are some questions that have come up in the chat. We will try to address those at the Q&A at the end, time allowing. The attendance code is up, and we are going to resume at 11:20. Thank you.
Okay, so as I said, I'm Ruthie, and I'm a staff attorney here in Indianapolis. And in particular, with the immigration court in Indianapolis opening probably in mid-January, I'm very excited to grow our pro bono network and get to work with you all. So let's look at this slide again and talk again about who the players in an asylum case are. So most importantly are the asylum seekers themselves. That also includes their family members who can sometimes benefit and receive a kind of derivative status from the lead applicant, and it includes their attorneys, so you guys and us supporting you. There's also the Executive Office for Immigration Review, which, as Lisa said, is housed within the Department of Justice and is basically just a fancy name for immigration court and also for the administrative appellate body, which is the Board of Immigration Appeals. And also, as Lisa pointed out, immigration court is not an Article III court. It's an administrative law court. So it's sometimes going to feel a little crazy in there to those of you who practice primarily in federal court or even in state court. Because this is an administrative law court, things like the rules of evidence do not control. They might be persuasive, but you better be ready for the judge to let in all sorts of things that would not be acceptable in federal court. So next is the Department of Homeland Security, and there are several sub-agencies in there that you may encounter as a pro bono attorney for an asylum seeker. So first, U.S. Citizenship and Immigration Services. That is the agency where you're going to file a work permit request for your client. That's probably the most frequent interaction you would have with USCIS as one of our pro bono attorneys. Also, as Lisa mentioned, ICE, the Office of Chief Counsel. So those are the ICE trial attorneys, our opponents. And then there's also ERO, Enforcement and Removal Operations. And if you're wondering why someone who's seeking asylum is already having to interact with enforcement and removal operations, that would be a good question. But many people who are seeking asylum in the United States have to wear ankle monitors and have their movements tracked. They have to prove that they're maintaining employment, and they have to go in person to check-ins with the enforcement and removal operations officers. So you as an attorney can counsel your client and help them feel more confident and less afraid going to those appointments and meetings. And finally, there's Customs and Border Protection. So that's going to be like your officers along the border. You're not going to be interacting with them directly, but your client may have paperwork from them, such as a notice to appear, or there could be other documents that they received at the border. And finally, the Office of Refugee Resettlement. Confused or a little bit randomly, this is housed in the Department of Health and Human Services instead of any of these other agencies. And you're probably going to interact or see paperwork from ORR only if you're working with an unaccompanied immigrant child. All right, so let's talk a bit about sort of a basic roadmap to the lifespan of an asylum case. As an attorney, of course, one of the first things you're going to want to know about your client's claim is who has jurisdiction over that claim. Who is the decider in your client's situation? So there are two ways that you can file an application for asylum in the United States. The first is affirmatively, and this is how people file an asylum application when they are not in removal, or commonly known as deportation proceedings. So people who might want to apply for asylum but are not in removal proceedings could be people who entered the United States without authorization but were never apprehended. It could be people who entered on a visa and either the visa is still valid or maybe it's expired. And also unaccompanied minors are going to be able to apply for asylum affirmatively. Affirmative asylum applications are filed with U.S. Citizenship and Immigration Services. And this, like Lisa, I believe, had pointed out, this is, or actually Jacqueline was talking about this. Yeah. This is not a court. This is not a court or a hearing. This is an interview with an asylum officer, not an immigration judge. But asylum officers, while they have jurisdiction, USCIS and asylum officers have jurisdiction over affirmative claims, asylum officers cannot order people deported. So if the asylum officer decides that your client's asylum claim is no good, they will refer your client to immigration court, at which point the client will be proceeding on their application defensively. Now, asylum applications can also originate defensively in immigration court. If somebody's already in removal proceedings because they were apprehended at the border, or maybe they've had some kind of contact with the criminal legal system and that's how they ended up in deportation proceedings, they can then assert their asylum eligibility as a defense to their deportability. Now, immigration court is housed within the DOJ, and the deciders there are immigration judges. Immigration judges have a lot more discretion than asylum officers, and they are not afraid to use it. And that can be good and bad for our clients. But you, as the attorney, want to make that something that benefits your client. So just because somebody lost at, or was denied asylum at the interview phase, immigration court is a whole new chance to make that argument, to make it to a new decider who has a lot more discretion. So strap in and make the argument well. If you, shockingly, if you were to lose at immigration court, which is not common for NIJC or our NIJC pro bono attorneys, you can appeal that decision up to the Board of Immigration Appeals. If that administrative appellate body dismisses your appeal, that's your last appeal you had as of right. At that point, you can petition the controlling circuit court, which for us is the controlling appellate court, which for us is the Seventh Circuit. You can petition for them to review, but you're not guaranteed that they'll take a look at the case. So For the rest of today, we're going to talk and focus about defensive cases because that's where the majority of cases that we are going to that we hope to assign with pro bonos are. They're in immigration court and people are seeking asylum as a defense to removability. If you are representing someone at the interview because they've filed their application affirmatively, you want to be looking at a separate procedural manual, and you'll be able to find that by following the link on the slide. Okay, so how do you know if your client is in removal proceedings? How do you know that? Well, the pro tip is that our case descriptions tell you if the client is in removal proceedings, but that's not enough. Just knowing whether they're in removal proceedings isn't enough. What you're going to want to see is their notice to appear, which is the charging document that places an individual into removal proceedings. You may have heard about NTAs during the 2020 Supreme Court term. There was a lot of litigation called Ms. Chavez about what information has to be on an NTA in order for it to be sufficient. It's important to note that an individual is only placed in removal proceedings when that notice to appear is filed with the immigration court, not when the individual receives it, which is often at the border. If your client has a notice to appear, but it has not yet been filed with the court, they are not currently in removal proceedings, but they could be later on, and they really could be at any time, which is kind of bonkers to just have this document hanging out and not be sure if you're going to be placed in proceedings where the government's trying to deport you. But like I said, this isn't federal court and things are a little different. So we try to resolve any procedural funkiness where an NTA may have been issued to the client, but they're not yet in proceedings. We try to resolve that before we give cases out or work with you all on the cases. But if you ever have questions about how this works or are a little confused, we're happy to answer questions. When I started doing this work, I had a lot of questions about that. All right. So once you've determined whether your client is in removal proceedings, here's what you're going to want to do first. So definitely review our procedural manual for asylum representation. I've been doing this for over 2 years now, and I was still remembering old things that I'd forgotten when I was preparing for this presentation, and I like to look at this manual whenever I've got a case coming up. You're also going to want to review NIJC's file, which is going to be the information specific to the client and their claim. And the more thoroughly you have reviewed the file before your meeting and meetings with your client, the more efficient the meeting is going to be for you and the more effective it's going to be for your representation. So for example, let's say you have a client from a certain country and you identify that in reviewing the file. Probably a good idea to maybe do a little background research on the country so that the client isn't having to explain to you from scratch things like basic geography or how the government works. And okay, so if you've determined that your client has an NTA and it has been filed with the court, at that point, you're going to want to file your appearance in immigration court. This is called an E-28. Before you can do that, you have to register for an account with EOIR. This is an e-registry process, and it's essentially where EOIR verifies your identity and gives you like a special number, kind of like your bar number, but you do need a separate one to practice in immigration court. Immigration court has like systems set up so that people can get through this a little more quickly and en masse. So that's something that we can guide you through. Something to note is that newer immigration court cases, so like after 2021, oftentimes you can file things online in ECAS, which is like so great. A lot of cases are older than 2021 because our immigration system is so backed up. And in that case, you're going to have to file things in person. I regret to inform you that the mail is so unreliable at the Chicago Immigration Court right now that you're likely going to want to try to have someone from your Chicago office walk filings over to the court. Now, when the Indy Immigration Court opens, many of our community members' cases will likely be moved to Indy. And so that will make in-person filing much less of an issue. So here's a handy trick. You can use your client's A number, which is a 9-digit number that will be on their NTA, and it's sort of like an ID number within immigration proceedings. You can use that to determine the status of their NTA or the status of their deportation proceedings. So you can go to this website here and type in the client's A number, and when you hit enter, you might get a number of different things. You might get a message that the A number is not in service. That probably means that it hasn't been filed yet. You may get a notice that you may get to a page that lists the A number and your client's name, but it says no future hearings at this time. That just means the court is so backed up that they haven't even given an initial kind of like programming or scheduling hearing date. And finally, you might actually see hearing info. And you're going to see one of two types of hearings, either a master calendar hearing, which is where you go and you plead and you give the judge kind of an overview of what you're thinking of doing for the client at a very basic level, and get some scheduling information about when your actual trial or your bench trial and merits hearing is. Or you might get a date for the merits hearing itself. So we are recommending that people who are representing non-citizens with A numbers be checking this web page once a week. And I know that seems like a lot, but especially with the Indianapolis court opening and a lot of courts getting sent down here, we just need to keep an eye on where our cases are at and if they're getting set for masters or merits. So the other thing you're going to want to do, like any good attorney, is calendar your important deadlines. So first, you definitely want to calendar the 1-year deadline. You got to make sure you know what the date is that is the time by which your client needs to have their asylum application on file. You're also going to want to calendar when your client becomes eligible for a work permit. So 180 days after the I-589 is filed, they can have a work permit. So that means you should file earlier than that. We recommend around 150 days. So calendar that 150-day mark after the asylum application is filed and start working on the work permit application at that time so that you can file it right away as soon as they become eligible. The other filing deadline, of course, is going to be when you have to submit your briefing. The default for that is 15 days before the hearing, but some judges want it sooner. So you got to make sure you check with your judge. Okay, so an important step is getting the background and the immigration history on your client, okay? There's no discovery in immigration proceedings. So the way that we get that information is we file FOIA requests. You file a FOIA request online and you can request expedited processing when you show that your client has a hearing coming up or is in removal proceedings at all. You really want to make sure you do this quite as soon as you get the case, because sometimes these results will come back in a month or two, but sometimes it can take a lot longer, and you don't want to be going into your merits without knowing, the information that the government has on your client. If you are representing a child who entered the United States unaccompanied, then you're going to want to request their file from the Office of Refugee Resettlement. You can also, if you're taking a case that's been in that has been in proceedings for a while, you might want an electronic record of proceedings. You might want to see how many hearings they've had. You might want to listen to the hearings, see what happened at some of the earlier masters. Did they already take pleadings, etc. Okay, and finally, you're going to want to make sure that you file a biometrics request. This is a critical step because if your client has not been printed and had their background check at the time of the merits hearing, the judge cannot grant asylum to your client no matter how strong their claim is. And they may end up postponing your merits for months. And in other circuits, we've even seen judges deny asylum outright because biometrics are not yet done. And like I said, this is not federal court, so it's going to be kind of hard to argue with the judge about that. Here's a useful chart of when you do and when you don't need to request biometrics. So if your client was printed at the border, or they received a notice that instructed them to report to USCIS to have their fingerprints taken in connection with their work permit application, you might think, oh, well, the government already has my client's prints, so we're good. No, you're not good. This is what happened to me at my first asylum hearing. My clients had been printed in connection with their work permits, and so I thought I was good to go. And I got to court and biometrics had not been done, and the judge was not pleased. So don't let that be you. What about if your client is seeking asylum in immigration court and they've never been printed? Well, that seems pretty obvious. You got to get your biometrics done. The only time when you wouldn't have to request biometrics would be if they're seeking asylum before the immigration court and they were referred there from the asylum office. But even then, you just make sure they were taken, and you're also probably going to have to ask for them to be refreshed, which is like rerun to make sure nothing has changed. That's a simple process that we can talk you through. Filing a biometrics request is just printing out a form and mailing it. It's not necessarily complicated, but it is critical. All right, and that's all from me. We're going to hear a little bit more from some of our wonderful pro bono attorneys.
Hey everyone, thanks so much for being here. My name's Jackie. I'm a lawyer at Fakery Drinker in the Chicago office. So for the next 5 minutes or so, I'll tell you a little bit about my pro bono experience with an asylum case. So this was an awesome case, and most importantly, it had a great result. This was my first asylum case. So the clients were a father and daughter who had fled from Mexico after receiving death threats. So the father was involved in organizing unions to object to working conditions. And our cartel in Mexico was unhappy with that. So they were sending him death threats. So he and his daughter left Mexico 6 years ago and fled and filed for asylum about 5 years ago when they came to the States. So as I said, it was a great outcome, but of course it was a very, very arduous process getting there, both for our client and for us. So the hearing was originally set in 2020, which was about a year after he had filed for asylum. But of course, the pandemic hits, so the hearing gets pushed, and it ended up happening in 2024. So that's a whole 5-6 years that go by from when he files and flees from Mexico. And other lawyers were on the case on the early end, and so they had really worked up the case really well. So there was a ton of factual development and a ton of facts that really helped our client. I mean, it really doesn't get better in terms of proving up a strong case when you have a family who's receiving death threats. And the problem particular to this case was that the cartel who was sending the death threats were so widespread in Mexico that there was really, no opportunity for the family to return to Mexico because there would be news potentially of their return, and then the death threats would continue. And so, to further help their case, other folks in Mexico who were part of the union had been killed. So there was, really strong fear and pervasive fear if they were to return. So we get to the hearing, and this was in Chicago. It was at the immigration court in Chicago. The government's attorney was actually very, very reasonable. So he stipulated to a lot of the facts that helped us. And when it came to the hearing, he asked actually a good bit of softball questions. So he asked a lot of questions that helped our client and helped actually prove our client's case. So we were pretty happy with the government's approach. The judge was a little bit more tricky. So this turned into a 3-hour hearing because the judge took it upon himself to ask a lot of questions of our client. And we were really surprised by this. We had worked a lot with NIJC, and, we thought this was a strong case. We were like, this might be a slam dunk. And it turned into a pretty rigorous hearing with a lot of questioning. So we finished closing argument, and the judge says, I need to go think about this. So he takes about 15 to 30 minutes to sit in chambers and to review everything. And of course, it was great news. But the judge had said, I came into this hearing and I was convinced that I would rule against asylum. And we were shocked by that. So we were, the oral advocacy at the hearing made a big difference. So the clients were thrilled. Of course, we went to an Irish pub afterwards to celebrate with them. And the next step after that, after they received their grant of asylum, was to get what's called an I-94 card. And that's a pretty simple and administrative process. That card basically finalizes the asylum rights for the new asylees. The problem was that took about 8 months. So that really should take maybe a month, but it took about 50 phone calls, 8 months. And the whole time we're thinking, well, thank goodness, that they have attorneys who can make these calls and kind of continue to follow up and push on this issue. So we were calling USCIS, which is the government's immigration service. And again, it was just compounding the frustration of feeling like, the very system that's supposed to be helping us, here we're at the stage where we've been granted asylum. This should be an easy process from here, that it was kind of complicated and unnecessarily frustrated. So eventually with it, like actually about a month ago, the clients got their I-94 cards. So we're really happy for that. So now they can, they have proof of employment and everything. And so I think the two big takeaways from my case have been, first, you need patience and persistence. It's shocking how much effort it takes, even on the simple things. And how, nothing's a slam dunk. We thought it was a super strong case, and you're going to face challenges, the pandemic, anything. So many things may throw a wrench, but you have to kind of keep going. And this good result is good encouragement. And then I think the other takeaway is, the system doesn't really care about your client like you do. So they care about it. This immigration decision is going to change their life. You care about it because we see, how much this changes their life. But the rest, the system, this is just another person, and they have a whole docket, and they're super busy, and they're just trying to get through their job. So I think it really means a lot, to your client, as lawyers, when you really care about the person and when their victory is your victory. So it was a really excellent experience. I think we all know that pro bono is such a meaningful part of our practice. So that's a little bit from me, and then you get to hear from the real star.
Oh, wow, high praise. My name is Nick Corbett. I'm a corporate attorney here at Fakery Drinker. So if you're worried that you're not a litigator, you can't do this kind of work, you absolutely can, especially with the help of NIJC. But so for me, I got brought in on a case that had been active for about 6 years, where a man from Morocco had fled due to being persecuted for being homosexual. And he was here, made his application, and then got lost in the system for 6 years. And over that time, through no fault of anyone, really, attorneys came and went. They would come to Fakery and sign on to the project, and then, they'd move on from the firm and necessarily had to move on from his case. And so when I got brought in on it, I think I'd been his 5th attorney over the course of 6 years. And he was understandably very frustrated and very nervous that this is just one more attorney who's getting brought in who will leave in a year to 2 years. And so for us, the most important part when we first started was to really rebuild a rapport with him, because one, they're talking about very traumatic experiences that happened to them that they don't necessarily want to relive, and they're telling it to a stranger who, for all they know, a year from now won't be involved, not to relive it all over again with someone new. And so that first meeting we had, I know as lawyers, we want to ask a lot of questions and probe and try and steer the conversation in a certain way. But this first meeting, I thought the most helpful thing was to just let him talk. Let him talk how he was comfortable talking and telling what he was comfortable telling, and just kind of being there and being a shoulder to lean on and reiterate that we're here to help you. We're here to ensure that you can navigate this complex system, well. And over the course of the next few meetings, built up rapport, and we were able to really narrow down and with the help of NIJC, put together a well-written brief that really outlined exactly why he deserved to be granted asylum. We had our hearing with the judge. It was over Zoom, so it was a bit complicated. We had some technical difficulties. Judge couldn't hear us, so that was not great. But we managed to overcome that using a cell phone and a computer and another cell phone. But the judge was actually very amenable to the case. In Morocco, it's legal to be homosexual, and that played a big role in the judge's decision. But I can remember after getting that positive result, the client was crying, I was crying. It was just a very, very emotional moment. And that was 2 years ago. And on the anniversary now, twice now, we've gotten lunch, and you see how grateful they are, and how much it means to them. And it really is some of the most impactful work that I think we can do as attorneys. So I really cannot stress enough how much I think it's a worthwhile endeavor. Thank you.
Thank you both so much for coming and speaking to your experience, and in particular for touching on the importance of building a relationship and building rapport with your client, because that is what we are about to talk about right now. We have a section on working with your client before we get into some more about preparing your case. Okay. So briefly, who are NIJC's asylum clients? As you can see from the screen, we have a really broad variety of people that we work with. NIJC's clients come from all over the world, from countless languages. They speak many languages and come from countless cultures. And they also come with a wide range of life experiences and fears and vulnerabilities. And so our hope is that everyone watching feels encouraged and excited to work with our clients, and is also prepared to meet them with an awareness of these differences. So some of the key differences that we want to highlight, some things to be aware of as you work with asylum seekers, largely have to do with the impact of their trauma on their case. And so it's not uncommon for memories to be faulty, or for our clients to have particularly difficult times discussing violence. Many of them have experienced violence related to their case. And many of our clients are very vulnerable here in the United States. So they might be housing insecure or food insecure, or have trouble finding work, and those immediate needs could seem more important than meeting with you to discuss their asylum case. And that can be frustrating as an attorney. And of course, their cases are very important, but we, ask that you have an awareness around that and have compassion about the importance of those needs as well. And then lastly, family dynamics could be complicated for some of our clients, particularly for queer clients who maybe have experienced harm at the hands of family members who they still care about and love. So it might be difficult to talk about that, or if they are living with family members and they're not necessarily out, mail might be something that you want to discuss with your client. So again, just having an awareness of all of these and ensuring that you meet your clients with that. At your first meeting, your main goal really should be to start building rapport with the client, and you will continue to build rapport throughout, but having that first introduction starting off right is really critical. So the main portion of the first client meeting should be introductions and small talk, ensuring that your client knows all of your team members, understands everyone's roles. Sometimes clients might bring family members with them to the first meeting. If, say, they get a ride from someone, in those cases, meet family members as necessary and then politely ask them to step out. And that can be a good opportunity to explain confidentiality as well. Remind your client that everything they tell you is confidential, so that you can start out with that base level of trust, and then get to know your client and their life in the United States, just to start to build a relationship. And this can also help with making a communication plan down the line. So your client works certain days, has certain hours where they can't answer the phone, right? Knowing that off the bat is going to help have a smooth communication plan going forward. And hopefully you can hit the ground running in your relationship and your work with your client. We find it can be really helpful to discuss a roadmap at that first meeting so your client knows where the case is going and has an opportunity to ask you any questions about their case. And it also signals to the client that you are aware of any upcoming deadlines and that their case is in really good hands. So again, you're starting to build that trust from the very first meeting. We do ask that pro bono attorneys explain the engagement letter with clients at that first meeting. And again, give them an opportunity to ask any questions so that they really understand the terms of your representation. And then lastly, in an administrative piece, it's to sign any forms you anticipate needing. So the G28, which you would use to enter your appearance as their attorney. If you plan on submitting a FOIA, getting that signature page from the client so that all you have to do is fill it out, confirm all the information is correct, and then you don't have to play back and forth to ensure that you have a signature so you can file it. In general, best practice is not to talk about the claim at the first meeting unless your client explicitly asked to do so. So as Nick mentioned, it can be triggering and hard for clients to talk about their asylum claims, especially if they aren't prepared and they don't quite know you yet. So this first meeting should usually be just about building trust. Maybe you take a case with NIJC that is urgent and you really have to hit the ground running. In those cases, we would put you in contact with a point of contact at NIJC and just ask that you discuss with them first what is appropriate to bring up and have a game plan so you can get as much done from that first meeting as you need to while also being considerate of the client's needs. All right. If you do work with an asylum client, some of them speak English. As you saw, our clients speak many different languages, so there's a chance you'll be working with interpreter, a high chance. And so we just have a few tips and tricks for working with interpreters on this slide. The bottom line is that your conversation is still directly between you and your client, and the interpreter is just there to interpret, right? So all those tools you would use for any kind of client conversation, active listening, direct eye contact, those should all still be used in situations where you have an interpreter. It could be useful to set guidelines and expectations with your interpreter ahead of time to ensure that you're on the same page. Asking short questions and avoiding compound questions are a great way to simplify things and hopefully limit the chance of mistranslation. And then limiting the duration of your meetings, taking breaks, both as a courtesy to your interpreter, who will be exhausted after a long session, and again, to keep them fresh, limiting the chance of mistranslation. So as you are working with your client, of course, you're going to have the big picture of their asylum claim in mind the whole time, and that consists of these three parts: the affidavit, the corroborating evidence, and the legal argument, all functioning together to support your client's claim. And I am going to talk a little bit about working with your client in connection with the affidavit, because this is probably where the bulk of your work with your client is going to be. Okay. So credibility is the most important part of an asylum case. And this can be based on many things. It can be based on demeanor, candor, plausibility, consistency of statements. But the adjudicator's credibility determination is primarily based on the affidavit and the client's testimony at the hearing, which means that the affidavit is the most important piece of evidence, of written evidence, that you are submitting in your case. And so with that in mind, we have a few tips for doing these affidavit interviews with asylum clients, probably all of whom are trauma survivors. This does require a new set of skills. It's not like doing any kind of client interview, so it's important that you come prepared with that knowledge and with some skills to meet your client. So a few tips are to meet frequently and for a limited duration, kind of similarly to that tip about working with interpreters. It can be really exhausting for clients to have to recall these traumatic events, and as I said, memory can be faulty, so meeting for a more limited duration hopefully will help limit that and will help limit the amount of time they have to spend in that emotional state where they're reliving things. It can be really empowering for clients to be given some kind of choice in these settings, whether that's as simple as asking them where they want to sit or offering them something to drink and asking what they want. It might be the case that you have a few different sections of the affidavit that you could cover. Perhaps you can ask the client which they would like to start with, right? And give them a little bit of autonomy in a process that can feel very powerless. As I said before, unfortunately, we cannot expect chronological sequence or complete consistency from clients just because of the effects of trauma on memory. This is really common. And so that's where you all come in as attorneys. It's your job to interview your clients, identify any areas of inconsistency, and fix them in the draft of the affidavit so that you come out with something that you can show to your client and read back to them and they can agree, yes, that's accurate, that's what happened. Asking short questions, again, simplifying things as much as possible so that the client can give a simple answer. It can be helpful to explain the objective of your questions as well, especially if you're asking about particularly difficult experiences that the client might not want to relive. So just reminding them that you understand that it's difficult, that you're asking because you think it could be really helpful for their asylum case, and maybe reminding them of confidentiality as well, right? That everything they tell you is completely confidential and safe. And then lastly, it's very, very helpful to bookend your affidavit interviews with asylum clients. So starting with some small talk and ending with some small talk so they can, even if it was a hard session, hopefully leave feeling somewhat stable, and not feeling like every time they come to talk to you, they're leaving feeling upset and dysregulated.
All right, I think I'm up to talk to us a little bit about kind of the nuts and bolts of preparing affidavits. I'm going to let whoever has the slides keep control, and I'll just let you know when we're ready to move forward. As Lily said, this is the affidavit. It's kind of like the crown jewel of your case, and it's sort of, you want to be doing all things in concert, doing your corroboration, developing your legal argument, and writing your affidavit. But really, until you've got that affidavit done, you can't finalize your brief. You don't necessarily know what all your corroborating work is. So this is really the first thing to tackle when you start meeting with your client. When we talk about meet early and often, I strongly recommend getting into a rhythm with your client. I think, everybody's schedules get busy and your client's got a work schedule and they've got childcare to figure out, and things get complicated and hard. But I think a best practice is to sit down at your first meeting and say, okay, for the next 3 months, we need to be meeting regularly to do your affidavit. So let's pick a day. It's okay to ask your clients if they can adjust their work schedule. It's okay to ask them if they can figure out childcare. This is a partnership between you and them. And in order for you to do your job as well as you can, you need them to be involved and to show up and be committed. And sometimes there's a little bit of pushing. You should do all those wonderful things that Lily described to support your clients and make them feel comfortable, but also giving them a very clear picture of like, hey, for the next X number of weeks, we're going to be meeting every Wednesday at 11 o'clock for 2 hours to work on your affidavit. I think that can be really good for your clients and really good for you because it sets the expectation. It's not this big looming thing that they have to worry about forever. And it's sort of like a thing you'll get in and do and get done. And I think to the question of like explaining the purpose of doing it, your clients will have done a long intake with NIJC. They will have told their story many times before. It's important to stress to them that you need to understand their case so that you can help the judge understand why they need protection. In my client counseling, I always put it on the adjudicator, on the judge. Like, I am so sorry I have to ask you these difficult questions and we have to go through the sequence of events yet again, but it is so important that we make sure the judge understands why you need protection. That's why we're doing this. So important points, make sure that your affidavit is in your client's voice. This is your client talking. During court, the judge will almost certainly have the affidavit open in front of them while they're listening to your client testify. So if there's like a huge mismatch between the language in the affidavit and the language your client uses, that does not help your case for credibility. That just tells the judge, hey, the lawyer wrote this, and this is not necessarily the client's testimony. So that's important. Tell the story chronologically, even though clients probably won't tell. They might have competing or different asylum claims and issues and things that happened at different times. I do think I've seen a lot of attorneys try to set up affidavits thematically instead of chronologically, and I just think the story needs to be told chronologically. Almost certainly the judge or the government attorney will really push your clients on the order of events and the dates. And so doing that work in the affidavit is important. Covering all the asylum elements. So again, the affidavit is not intended to be like a full biography of your client's life. The asylum affidavit is intended to capture the events in your client's life that give rise to their asylum claim. And then consider length. We have a slide coming up, and we can shift forward to the next slide about, what are the things that NIJC most often corrects or offers suggestions on when we see your affidavits. I would add to our list length. I teach Notre Dame law students asylum, and I tell them in their asylum affidavits, boy, if you're getting over 10, 12 pages in your asylum affidavit, it might be too long, because you're locking your client into a whole lot of detail that they're going to be expected to recount under the stress of an adversarial hearing, under cross-examination. And so keeping your affidavits somewhat concise, I think, is really important. So we can go ahead to the next slide. I think we had a few questions about what are the issues with these, or what are the challenges here? And you can go ahead, whoever's doing slides, and just pop open all of them. We're going to keep moving pretty quickly here. But, some of the mistakes we make in affidavits, because we're lawyers and we really, really want to make the legal argument, is infusing legalese into the affidavit, saying, my name is so-and-so, and I belong to the particular social group of Guatemalan women in relationships they're unable to leave. Again, that's your job in the brief. You get to do all this super fun, persuasive writing, legal argument when you write your legal brief. The affidavit needs to be in your client's voice. To that end, the next quote is one I pulled from a case we picked up from another attorney on appeal, where the affidavit said, this is a teenage boy, a Central American teenage boy, in his affidavit read, when I told them I did not want to join their gang, this triggered a melee and the whole group involved in kicking me, and police belatedly came to ostensibly investigate. Their investigation was cursory and superficial. CTAB, Department of State Human Rights Report. That's not what the affidavit is for. That's not what your client sounds like. Those aren't words that your typical Central American teenage boy is going to use, and you're certainly not going to cite to your exhibits in your affidavit. Again, that's what your brief's for. That's where you do all that fun lawyering stuff. In the affidavit, you really want to capture your client's voice. The third one, this one is really easy to do, because your clients will, you may interview them repeatedly and they'll say the same date over and over again and the same number of people that encountered them. And then you'll get into trial prep, or worse, into court, and suddenly dates shift and numbers shift. And it is our job to not lock it. This just happened to us last week. We have a client we're preparing for trial next Wednesday. And we had been very careful about this. And sure enough, the number of people that she said attacked her went from 4 to 2. And we had backed off assigning specific numbers in the affidavit, so there was space for that. But never put precise dates, never put exact numbers of attackers. People don't take a head count when they're under attack by a group of gang members. And so just give your clients space for those things to shift. So that last one is a good option. Around May of 2010, or I would even say spring of 2010, or if it's from a country that the seasons are different, during the rainy season, or, just keep things general so you've got that space. Let's pop to the next slide, which is, I believe, the things, we've just talked about this. I guess the one thing that I will, context and background, especially if your client is coming from a cultural context that's very different. Don't assume an immigration judge, even if that immigration judge has heard lots of asylum cases, understands sort of how a village is laid out in El Salvador, or what it means to collect food in a different, some of these things, if you're not familiar with them, the judge likely won't be either. And so take the time to spell out some of that stuff. Instead of saying I'm a Salvadoran woman who sold pupusas, maybe we all know what a pupusa is. An immigration judge might not. You certainly don't want to spend 10 minutes in court going back and forth with an interpreter explaining a pupusa is a traditional Salvadoran street food involving ground corn and filled with beans and cheese. Just say I sold traditional food, or I sold tortillas. Do those simplifying things, and think about how it's going to, play in court so that the story comes through most cleanly. And then consistency. Be looking back at that I-589. Sometimes the asylum application was filed 2-3 years ago or more. and you're now writing an affidavit, make sure that your facts are aligning. If you need to amend your I-589 because something has shifted, that's okay. We can help you do that. But do make sure that your documents are consistent. Do make sure if you've got, Jeff's going to talk in a moment about corroboration. If you've got these awesome letters of support from family members and friends and siblings or whatever, make sure those are consistent with the affidavit, because you just don't want to have that like low-hanging fruit where a government attorney or a judge can find contradictions and use those to undermine your client's credibility. Let's go to the next slide. Corroborating your case. This is the second most important thing. And what's really wild about corroboration in immigration court is under the Real ID Act, a judge can require any corroboration they think is reasonably obtainable. So you don't get a list. We don't have a status hearing early on where we all agree, okay, this is the scope of evidence of corroboration that this client needs to produce. And we've litigated this, and judges are not required to tell us what is that evidence that they need. So you need to sort of review the possible universe of evidence that your client could produce and determine what might be relevant to support the case. There's this lovely regulation that says that testimony alone can suffice. In practice, judges are going to ding you if they think you should have evidence that you don't have. It's okay if there's evidence that's unavailable to you. You just need to explain why you can't get it. So for example, I had a client recently who couldn't get letters of support from her sisters who had observed her abuse because the sisters were living in really dangerous situations, and their phones were being monitored, and they couldn't talk to us or WhatsApp us or send us anything or email anything. So we explained that in the client's affidavit, and she was ready, and sure enough, it came up on cross-examination, and she was able to explain it again. So you don't have to put anybody in danger to obtain corroborating evidence. You do have to explain why you can't get things that it seems like you should have. Okay, let's go forward again. So what are the things that you should get? I think this is a useful chart to keep handy. One thing I think early on that's useful to try and figure out, like as you're interviewing your client for their affidavit, I usually have like little checklist going of like, okay, what's the corroborating evidence that might be available? If your client is talking about any kind of residual harm, medical issues, scarring on their body, we just had a forced sterilization case, things that you would want medical corroboration for, those are things you want to get moving on really quickly, because that can take a while to obtain, and that stuff a judge is really going to want to see. And so moving on, forensic medical, forensic psychological, if you have a client that's really, really struggling to testify, it might be useful to have a forensic evaluation from a psychologist talking about, we've had clients that have had documented, cognitive deficiencies resulting from the type of abuse that they experience. So those things can be really useful. And then again, the federal rules of evidence don't apply. So like anything that's fundamentally fair can come in. So if you've got pictures, if you've got, we do a lot of screenshotting of, Facebook pages and WhatsApp messages and threats that came in various ways. Those sorts of things are useful to include. So those are the things, as your client is referencing that to you, you should be thinking about how you might track that down as corroborating evidence. Let's go forward. I think our next slide might be the hypothetical, which I'm thinking we should hold off on for now because time is of the essence, and we will shift to Jeff to talk a little bit more about corroboration. Then we can circle back for this if we have time.
Thank you, Lisa. Yeah, and so continuing along that same line with corroboration, just some kind of very general key pointers for how to go about it. Most important thing, work with your client. No one knows what documentation is available or why it's not available better than the client does. So that's the first place to look and first place to talk through this. For any corroborating evidence, you want to establish the chain of custody. We don't mean this in like the formal sense, the way you would, for introducing evidence in a criminal trial, but you need to know that it's a reliable document. You need to know how it was obtained, what evidence there is of the document's origin, depending on the record keeping practices of whatever country we're talking about. The level of evidence may change. This is something we can consult on. But you want to know what evidence there is of the document's origin and what there should normally be for this type of document. Most importantly, if you have any doubts about authenticity, leave it out. And this might be just someone got a document from like a quasi-government official that they thought was legitimate, you really don't think it is, and you just don't feel comfortable using it. We don't want to, as Lisa was saying before, with other things, we don't want to put something on the record that would be low-hanging fruit for someone to point to as an issue. So if we have doubts, keep it out. Rules of evidence do not apply. They are persuasive guidance, but we're not bound by them. So as Lisa was saying, if it's fundamentally fair and probative, then this is something that you can introduce. And so think outside of that rules of evidence framework. Foreign documents need to be translated into English. There needs to be a certified translation. Anyone competent to translate can certify, but they need to sign that certification. Again, as Lily said, all the parts of this come together. So corroborating evidence, affidavit, legal argument, you're thinking about all of them at the same time, moving back and forth between them. So when you're working on your brief, you're thinking about what's in the affidavit, what you can corroborate, and how best to fit all of that into a persuasive legal argument. We want to keep to the 25-page limit set by the immigration court. We often get questions about, should I file a motion for additional pages? That does technically exist an option in some outlier cases. But in most cases, even if you have multiple claims for relief, even if you have multiple family members, we really want to keep to that 25-page limit because that is what is going to be easiest for the immigration judge to digest, and we want to make everything clear and concise. Keep those elements separate that we talked about before. We do not conflate the elements, go through it step by step. Well-founded fear, harm rising persecution, and persecutor as a government entity or one that it is unable or unwilling to control. Nexus, protected ground. Move through the elements systematically. If you are practicing in the Chicago or Indianapolis court, focus on the Seventh Circuit case law. There are very significant distinctions between the circuits, and you want to make sure you're looking at what is controlling. If you're working with us, send it to review. We will be enthusiastic to give any comments and suggestions that we have that we can. The more time you give us to review, the better. And if you take a case, we'll give you specific timelines for doing all of that. And of course, importantly, you want to preserve all arguments and claims to relief. This kind of is probably what Lisa was talking about before with even if Convention Against Torture relief is not your desired outcome and it's not the strongest part of the client's claim, we want to make sure that we preserve that in the briefing so that would be available, or it's something we could argue on appeal. Similarly, for all parts of the argument, all types of claims of relief, we want it to be represented in the briefing so that those issues are preserved for appeal. A few things to keep in mind while the case is pending. So meeting with the client, establishing rapport, building up the affidavit. If you're doing that from the beginning, that is crucial. It takes time and there's no way to rush that. Similarly, with the corroborating evidence, you want to be thinking about from the beginning what you need and how long it's going to take to get those things, and be working on that as the case moves along. If the client has either medical, therapeutic needs, mental health needs, we can help with resource lists for local providers, and connecting them with that can be both very useful for the client and also can help get a basis for so that medical corroboration that Lisa was talking about before. Stay in contact with your client. Again, most of these cases are not going to be like Jacqueline's where it's 13 years of contact, but cases can take a while to resolve. And I know everyone has other priorities. There are other things on your plate, but you want to make sure that you're not just kind of losing contact with the client for years at a time and then coming back when you need the next work authorization renewal or something like that, right? You want to have a regular set contact so that they are updated on your case and that you know that you will be able to contact with them and resume work as soon as the date's scheduled. Work authorization. Very, very, very important to our clients. This is their livelihood, their ability to lawfully work in the US. As Ruthie mentioned before, work authorization is tied to the asylum applications, and so we will be, your teams will be helping with the work authorization renewals as they come up. And it is very important to calendar those deadlines and get those applications in timely, because this is how the client survives in the world and provides for their family. So the calendaring is absolutely crucial. Make sure you always know when deadlines are coming. If it's their very first EAD, employment authorization document, that will be with no fee, and you can apply 150 days after the asylum application is filed, and usually there's a shorter turnaround time for processing. The renewals are slower. There's a fee or possibly a fee waiver available. Thing to remember here is you want to apply 6 months before the current EAD expires. So that's the date you want to be calendaring for the renewal applications. Filing guidance changes. A lot of changes with all of these agencies. And so you want to confirm the current guidance and fees online. This is also something NIJC helps you track. There are online and paper filing options. And just want to make you aware of that. Again, this is something we could discuss more at length for a particular case. NIJC point of contact can provide all relevant guidance, and we have some links on here that we would also circulate if you took a case, that just for how you check the processing times and the case status. You also, as part of keeping in touch with the client and keeping up that relationship, you want to know, and your client will be told from the beginning that they should tell you, and they should be reminded they should tell you, if there are any major events in their life. A marriage, being a victim of crime, birth of children, things like that can have immigration consequences, both positive and negative, depending on the context. And so arrests similarly. And so you want to try to stay up to date on what's happening in their life and make sure that they are telling you any major life events, and communicate that to NIJC if there's any major event. And regarding other immigration benefits, sometimes an individual will be eligible for things other than asylum. And the key thing to keep in mind is they should be consulting with you, and you should discuss with us before they apply for any other kind of immigration benefit, because we want to be careful about how that interacts with the application we are representing on. And with that, I will turn it over to Cecile to talk about how to actually present this case after you prepared it. And actually, I apologize, Cecile, before I do that, let me give you the other CLE code word for when you fill out the survey. And that is going to be list, as Lisa will promote at the end of this, and we will talk about in follow-up emails. The NIJC case list is what you can consult to see the asylum cases that we currently have available and pick them. The cases that Jacqueline, Nick, and Jackie talked about, that's where they originated. Emails asking to represent someone on this case list. The 4 cases that I read little summaries of early on are all on our current list. And so if you're interested, this is where you look to take the next step in getting it involved. We will come back to that again later, but now I really am passing it over to Cecile to talk about presenting your case.
Great. Thank you so much, Jeff. So when you get to this point, presenting your case, that's really great news, because that means that you have an actual merit date. And you're going to start, you now have something on your calendar that you can start working towards. And this, we've talked about a lot of things today. There's a lot of information, but remember that that's why NIJC is here. We have pro bono attorneys on our staff who work just with pro bono teams to help guide you along on this journey and help you with from beginning to end in getting your client's case to court. So first, let's talk about what to file. So remember that now the case is in immigration court, and the immigration court is the Department of Justice, but the opposing counsel is with DHS. So everything that you're going to file, you also have to serve the Office of Chief Counsel, and they're with DHS. So when you're in immigration court, it's important to file an appearance. It's in the court, it's called an E-28. It's similar to a G-28. It's a two-step process. First, you will register with EOIR. You'll receive a number by email, and then you will next either go to court to show in person your identity so that you can prove your identity. Also, in the Chicago court right now, we have pro bono attorneys have the ability to go on WebEx at certain times and days, and we'll let you know when that is, where the judge will check virtually your identification documents. Also, you will file the asylum application, which is the I-589. I'm not done yet. I'm sorry. Okay. So with the brief, we talked earlier about the brief and the corroborating evidence that has to be in a specific format. So it's always helpful to look at the immigration court manual just to make sure that you have all the elements and that you have all the requirements that are met. The annotated index and any of the supporting documentation. Next slide, please. Okay, so in addition to your brief, you also will need to present any corroborating evidence. That means any identity documents like a birth certificate if they have it, a passport, the affidavit of your client, any kind of affidavits from witnesses if you have it, expert affidavits. That all needs to be presented in a specific index that is helpful for the judge to find. So it needs to be tabulated. And so on this form here, on your left side is what generally it's going to look like. So make sure that the tab is there. And then in the middle section, there is the evidence that you're going to be presenting. And then on the right there is the page number. You're going to take your stack and you're going to paginate it, and then it will show on your index for the judge to see where that is in the brief or in your evidence. So we talked a lot about country conditions evidence and also other corroborating evidence that is going to bolster your argument for your client. And some of the tips that I can share with you is one, consult us. We've done a lot. We've done a lot of this. We have many different countries that we've worked with that we've done research for, and so we can help you with samples. Also, while you're looking at, say, the State Department report, it's helpful if you start pulling out the quotes then that you're going to use and put them on a skeleton of your index. And that way, later on, you're not going to be looking for that specific quote if you need it again. If you don't need it, you can take it out, but it's helpful and it's a time-saving tool. Also, if sometimes it's transcripts of, sometimes you have videos or audio that are part of the evidence. You can take screenshots of the video and also get transcripts of the audio. And finally, you want to use recent examples because the government is going to try to say that things are better, the outlook is better now in the country of origin or the country where the asylum seeker is from, and then you would want to show that it has not changed. So all the recent corroboration is going to be from those articles and those reports. Filing format, we touched upon this earlier. Really, the only way that you can know if you have to file electronically is if you try to file something electronically. And then the portal will either accept it or it will say, this is a paper filing. So with a paper filing, Again, make sure that you look at the Immigration Court Practice Manual. It has to be in a certain format. There needs to be a 2-hole punch at the top. If you don't have a 2-hole punch, they have one at court. So if it's a paper filing, you'll take, usually I'll take the original and a copy with me to court and have those dates stamped. And then take the copy, one goes to court, and then your copy, you will serve a copy of that to DHS. And you can either do that by mail or through the e-service portal, which is easy, and then we can show you how to do that as well. Don't forget to tell your client that this is a mini trial. So prepare them as much as possible. Let them know there's going to be a judge, that there's going to be an opposing counsel, and there's going to be yourself, and the client's going to be testifying. We suggest 3 types of preparation. The first is a full prep, so that they can kind of get an idea of what the entire hearing is going to be about. Start with, asking them questions, the direct examination, what the opposing counsel might be asking, and also prepare them for the judge to ask them questions. The second preparation meeting, we suggest that you have a really tough session with your client. That way they know what to expect, find the holes that are in their argument, in your argument, or in their story, and really ask them the tough questions so they know what to expect and so that they're comfortable when they go in there. And then the last prep session is a confidence builder. Let them know that you think their story is strong, that they have a really strong case, and that you believe in them. And whatever questions they might have, answer those questions. Also give them the opportunity to know that they can ask for a break if they need it. They can ask questions. They can ask something to be repeated, or that they don't understand something, and that gives them a little bit of empowerment during the hearing. I feel like I'm talking so fast. Make sure that as you prepare for the merits hearing, we will let you know who the opposing counsel is going to be. That information comes out to us, and we will share it with you. And then you get a little bit of intel if this person is going to be as amenable as Nick's opposing counsel, or if they could be a little tougher. Also, we'll let you know whether the judge is a little bit tough, because we do have a lot of these. Make sure that you review the procedure manual that NIJC has on their website, so that you get an idea of what the hearing is going to be like. And I like to also give to the people that I work with as pro bonos links to mock hearings. And those are really, really interesting to see, because then you kind of get an idea of what it's going to be like when you are also going into the hearing. Generally, the hearings are open to the public, but we don't like to throw you there just in case the client would like a little bit more privacy. Okay, so after the merits hearing, there is no better feeling than getting the asylum granted, as Nick talked about. It's such a relief, and it's also such a joyous occasion. Make sure that you let us know right away. There is a limited window for benefits for people who are granted asylum. Help them obtain their I-94, which is normally, it's just literally like a piece of paper that's mailed to them. If it's not mailed to them, you can let us know. We can give you the information about contacting USCIS on their behalf, and help them with their work authorization if they need it to be extended. And also at that point, they are going to be eligible for an unrestricted Social Security card and other benefits. And then in a year, they will be able to go through what's called adjustment of status. We won't ask you to go all the way to that point. At that point, then we can give them information about nonprofit organizations and private attorneys who can help them. If the asylum is denied, that is really, really devastating. And, that's something that you might also want to prepare yourself and your client for. Make sure that at the end of the hearing, if it's denied, reserve appeal. Let us know immediately, and we can help you appeal to the BIA, the Bureau of Immigration Appeals, and work towards that. Okay, so then your case is over. You can breathe. You can celebrate, like go out to the Irish pub. We'd love it if you take another case with us. Once a case is over, we have an opportunity to have more cases that people can take. Recruit your colleagues. It's nice to have teams that know each other. Donate to NIJC. And then wherever you are, please advocate for justice for immigrants. And I think and thank you. Thank you so much.
Yeah, thanks, Cecile. Thank you, everybody, for staying on 4 minutes overtime. We've packed in a lot of information. When it comes to preparing for trial, that's when we strongly encourage you to reach out to whoever your contact is at NIJC, whether that's Jeff, Cecile, Olivia, Julie, to talk through the nuts and bolts of trial preparation and the hearing, and refer back to our materials. And we hope to support you in every way as you prepare for that moment. We've reached the end of our training. We wanted to have time for Q&A. I think the NIJCers who are on this call are willing to stay on. And so we know you might have other obligations in your day. And so if you need to drop off or you need to leave the room, we totally understand. We're also happy to hang out for a while if people have questions and want to stay on and chat. Please do use the QR code on the screen. We need you to do that so we can get you your CLE credit. Jeff gave you your CLE code words. Hopefully you wrote those down and have those handy. And then just another, invitation to review our case list. If you already have an asylum case that you're working on, thank you. We are so happy to be working with you. If you don't, and this has piqued your interest, please take a look at the case list. It'll be circulated to everybody who's been a part of this training. Please contact us about taking a case. We would love to partner with you, particularly as we enter into a challenging season for asylum seekers. So with that, I will pause. And if you need to leave, you should leave. And we are so grateful for you being here. If you want to hang out and you have questions, please either come off mute and ask your questions or drop them in the chat. And I think we had a few that we'd saved from throughout this conversation. So my colleagues might pick up a few of those to get the ball rolling. But again, thank you all so very much for your time. We're incredibly grateful for you spending this morning with us.